Hi, and welcome back, everyone, from our lunch break. This is the second half of our second day of the 2024 Respectful Workplace Week Forum. So as a reminder to anybody coming back or just joining us for the first time today, just be aware that all our audience members' microphones and cameras are turned off because this will be a webinar style presentation for the day. And the chat is also disabled for the audience. So you'll receive some links and some information in the chat, but you won't be able to contact anyone in the chat. You are welcome to send us your questions and your comments using the Q&A function at the bottom of your screen. So I'll be monitoring those and posing your questions to the speakers towards the end of their session. If you need to reach the hosts for any other reason, including for tech support, feel free to do so using the Q&A function as well. We have simultaneous translation available, which you can access using the drop-down menu at the bottom of your screen. See where it says interpretation and choose the channel you need. And as a quick reminder and request to our speaker, please go slow to help our translators keep up. So thank you so much for joining us for this next session, which will be a discussion on the duty to accommodate at work and the rights and responsibilities of employees and employers. We're joined by Megan Griffith, the director of the New Brunswick Human Rights Commission, who will be giving this talk. As an educator by training, Megan has held several roles within the government of New Brunswick with responsibilities for information privacy, legislative affairs, and policy. In her current role as director of the New Brunswick Human Rights Commission, Megan is focused on delivering an effective and efficient compliance process and educating New Brunswickers on their rights and responsibilities under the New Brunswick Human Rights Act. So Megan, I'm going to hand it off to you. Thank you.
Hello, everyone. Welcome and thank you for joining us today. I'm very excited to be here to talk a little bit about the rights and responsibilities under the Act. I am going to share my screen. I do have a presentation, and I'm just going to make sure that everyone can see this the way that I'd like to. Perfect. Amber, are you able to give me a thumbs up if folks are seeing that in a presentation style?
It looked like it for a second, but now I see the PowerPoint app again.
Okay, just bear with me for a second.
Sure.
One moment.
Take your time. Oh, there we go. I can see your
Perfect.
full
Okay,
slide now.
great. There's always
Thanks.
that button to find. Okay, thank you, Amber.
No.
Thank you, everyone, and thank you for joining me today. As Amber mentioned, my name is Megan. I'm the director of the New Brunswick Human Rights Commission, and I'm really excited to talk about the duty to accommodate at work, which includes the rights and responsibilities of both employees and employers. I've been at the Commission for about 4 years, and in this role for about 1 year. I use she, her pronouns, and for those who may be less able to see me, I am a female. I have brownish hair, and I'm wearing black today. So welcome and thank you for joining us. So a little bit about the Commission. Before we start talking about the duty to accommodate under the Act, it's important to know where the duty stems from. And so the New Brunswick Human Rights Commission was established in 1967, actually one of the earlier commissions in Canada. It was the second one. And we are responsible for administering and ensuring compliance to the Human Rights Act. So that means that we investigate, we conciliate, we mediate complaints of discrimination and harassment. And we also have a mandate to advance equality through education like this and other educational events that we would have through the year. The picture that we have to our right just shows the original signatories, which is an interesting piece of history. So the Act in New Brunswick is quasi-constitutional. And so what that means is that it overrides other things. So it can override collective agreements, contracts, other laws, for example, like the Employment Standards Act or industrial relations. And it's only the Canadian Charter of Rights and Freedoms that supersedes the Act. And the Act is not punitive, rather it's remedial in nature. And so oftentimes you'll hear people say you can't contract out of your human rights. That's a little bit about what they're talking about here, meaning that even if you sign a contract or even if it's already in another piece of legislation, it doesn't necessarily mean that your human rights don't apply. As well, the idea of it being remedial in nature as opposed to punitive, we'll talk about a little bit later, but that means that we generally in New Brunswick would not see million-dollar awards for losses, for example. So our process is designed to make the person whole, not necessarily to compensate in the way we might see in other legal systems like the United States. Our Act provides protection for 16 grounds. So originally, the Act only provided protection for approximately 5, which are the first 5 that you kind of see on the left. So race, color, national origin, place of origin, ancestry. It's grown over time, with the most recent change being made in 2017, which added gender identity or expression and family status to the Act. It also protects against reprisal and sexual harassment. So reprisal means either that you filed a complaint or you assisted with the filing of a complaint. Maybe you participated in an investigation. And sexual harassment would be sexual harassment in the context of any of the areas that the Act covers. The areas that the Act covers are employment, housing, commercial space or property, business or trade associations, services, facilities, or accommodations, and publicity. So employment, fairly obvious, though it can include things like volunteer work and other forms of employment. Employment in human rights law is very broad. So there's a lot of things that can fall under that category, even if they aren't maybe traditional employment. Housing, that can relate to, maybe it's an apartment rental, it could be a contract, it could be going to see an apartment to rent, it could be purchasing a home or a space for your business. Business or trade associations, that's going to include things like maybe unions and other professional associations. Services, facilities, or accommodation. This is any service. So if you go to the mall, if you go to a small business, this also includes things like education. So if you have a child in the school system, it falls under services. And also publicity, that would be notices, signs, or symbols. So that would be anything that's displayed, anything that's printed in a newspaper would fall under that category, but it doesn't generally include like email notifications and things like that. It has to be generally publicly displayed. So because we do accept complaints, we have a compliance process. And so this is a little bit about what the process looks like. There's a few kind of side steps and side quests that you can take through this, just depending on how your complaint flows. But basically it starts with an intake. So that's either that you file a complaint with us or that you contact us about a situation that may be occurring. We'll talk to you, we'll give you some information, and then you might choose to submit a complaint. A complaint form, it's available on our website. It's a formal document. You fill it out, you put your name on it. It comes back to the commission and we take a look at it and we triage it. So we just determine, okay, first of all, is this something that we have jurisdiction in? So if you're talking about maybe an event that happened to you while you were traveling in Ontario, that would likely fall under the jurisdiction of the Ontario Human Rights Commission and we might direct you there. We're also going to look at, is there anything in this that's really urgent? Is this a situation that's already happened and it's kind of done, or is this ongoing, for example, an accommodation in employment or an issue with your housing provider? And so we'll triage it accordingly. After that, because it's a legal process, if there's any errors in the complaint form, we'll do a complaint form revision. So you might have checked, maybe you checked off housing, but you meant to check employment. We'll go through that process. And then one thing that's important to note is that when you file a complaint with the commission, it's not anonymous. So if you're filing a complaint about your housing provider, your employer, they're going to receive a copy of your complaint. So we'll have a conversation with the person filing the complaint about what the process looks like. And then once they give their consent, we'll share that with whoever they filed their complaint against. At that stage, once we've contacted what we call the respondent, so whoever you filed your complaint against, there's two options. The respondent can indicate that they're interested in mediation, or they can file a response to your complaint. Mediation is offered by the commission. It's voluntary. It's a no admission of liability basis, so it means no one admits fault, and it's completely confidential. Any information that's disclosed in mediation can't be used against the parties. So depending on what the parties agree to, we'll either mediate and hopefully reach a successful conclusion. If it's not a successful mediation or the mediation fails, then we'll get the respondent's response. So essentially their side of the story. They'll explain to us their perspective on the issues. They might provide evidence or supporting documentation. And then we give that to the complainant, so the person who's filed the complaint, and they have the chance to provide a rebuttal. Once we have that whole package, so the original complaint, the response, the rebuttal, it goes back to our registrar who takes another look at it and decides, okay, what needs to happen with this complaint? Should this complaint be dismissed because the information doesn't support a case of discrimination, or should it proceed to investigation? If the determination is made that it proceeds to investigation, there's a number of files that are awaiting investigation. Once an investigator is assigned, they can do things like conduct interviews or ask witnesses questions, ask for documentation. After they've done that, they write a report. It goes out to everybody who's a party to the complaint. That report is then presented at a commission meeting, and the commission members decide whether they agree with the recommendation in the report or not. The commission's a little bit unique in government in the sense of we have commission staff who are civil servants, and then we have commission members who are appointed by the lieutenant governor and who serve a term and are basically there to represent their community, to review complaints of discrimination and the recommendations, and then make the decision as to what to do with them. Commission members can generally decide that a complaint should be dismissed and the file should be closed, or that it goes to a board of inquiry, which in New Brunswick is the Labor and Employment Board, and it's only a board of inquiry that can make a finding of discrimination. The New Brunswick Commission essentially acts as a gatekeeper. We don't have the authority to determine that discrimination occurred, only to kind of dismiss complaints where the information doesn't support it and to let complaints flow through to a board of inquiry where the information supports that there is an arguable case of discrimination. We also have a few other processes, for example, appeals. If a complaint is dismissed, an appeal can be filed. That's if it's dismissed at the director level, not once commission members have seen it. We also do education and communication. So we have a Facebook page, we issue statements. And so that's kind of the basics of what the compliance process looks like. So if you're thinking about the compliance process, the first thing that you need to know is really what is discrimination and what does that mean in New Brunswick? Because human rights is a very broad umbrella and discrimination can mean different things to different people. So discrimination means differential or non-differential treatment on the basis of one or more of the protected grounds under the Act. So for example, policies that might be fair and equally applied to everyone could actually have the effect of being discriminatory. Unfair treatment does not necessarily mean it's discrimination. So an example of that would be sometimes we'll get a call from someone and they'll say, my workplace is really awful right now. My boss comes in and they're very upset and they're yelling at everyone and it's not a good place to be and I'm really uncomfortable. The only way that the Act in New Brunswick would apply is if that individual is being treated differently because of who they are, because of one of their protected grounds. So questions that we might ask would be like, okay, is your boss treating everyone the same way, or does it seem directed at certain groups of people or certain individuals? And we'd work through that process. But the only way that the Act in New Brunswick applies is if the individual can make a connection or a nexus between I have this protected characteristic, for example, a disability, your race, perhaps your gender identity, and I am being treated differently. And here's how that's happening. There's also no requirement that there's any intent to discriminate. And we do see this sometimes. Sometimes decision makers will do something that they feel is in the best interest of an individual without actually consulting with them about that. And that can have the effect of being discriminatory as well. And that can apply, and we'll talk about it a little bit later, but certainly sometimes people have a perception about a disability and that perception doesn't apply to the individual. And so it's important to note that even if there's no intention, even if there was no kind of malicious intent to discriminate, it's still possible that that could occur. So what does discrimination look like in employment, for example? So it can occur as early as the hiring process. So it could be asking intrusive questions. So asking, do you have children? How long have you been in Canada? Are you married? Things like that, and using that information to make a decision about who should have the position. It could be posting a job ad that excludes protected groups. So you could say, we are only seeking male candidates. It could be not hiring a candidate because they have a protected ground, like a physical disability, so that they use a wheelchair or they use a cane. Maybe they have vision loss. Or withdrawing an employment offer upon finding out that the candidate has a protected ground. So perhaps an interview occurs and it goes very well. An offer is made to an individual and they disclose after the fact, okay, I see that the start time is 8:15, but I have childcare obligations and I'm unable to secure childcare before 8:30 because of maybe the time my children's school opens or because of the daycare availability. And the employer says, well, if that's how it's going to be, then we don't want you working here. So it can occur very early in the process, and it can also occur at any time during employment because people's situations change. Everyone is just one accident or illness away from needing an accommodation. And so during employment, the situation can also evolve. So it could involve, for example, a demotion of an employee, or withholding a promotion, not exposing them to the same opportunities because they have a disability or are part of a protected group. It could look like a refusal to accommodate somebody because maybe they've developed a disability or they have a disability that now requires an accommodation. It could be terminating an employee upon learning that they belong to a certain group. So it could be, we've seen examples where, I didn't know that that was your religion. That doesn't fit well with our culture here. These aren't specific to New Brunswick, but we've seen them in case law. Or permitting coworkers to harass an employee based on a protected characteristic. This is one that can start very small. It can start with one little comment or one little joke. Maybe someone has poor handwriting because they have a disability, and someone says, "Oh, wow, you've got some messy handwriting." And suddenly that becomes almost like a running joke or a theme, and it creates a culture where that employee no longer feels welcome, where they feel made fun of, where they don't feel comfortable, they feel misunderstood. And so these are things that can happen early on. They can also grow over time. So under human rights law, employers have a legal obligation to accommodate reasonable requests for accommodation from employees and from potential employees if they're related to a protected ground. So that could mean making changes or adjustments to policies or practices. It could mean changing the physical space, providing different tools, different supports to meet the needs of employees under the Act. And this accommodation duty involves kind of three principles: dignity, personalization, and inclusion. So, dignity cannot be lost through the accommodation process. It should not be diminished through the accommodation process. When employees are treated with dignity, discrimination is less likely to happen in the first place. And we don't want to see employees being marginalized, stigmatized, devalued, or kind of put in a little silo set to the side. Accommodation should never humiliate or stigmatize the employee requesting an accommodation. So an example of this could be perhaps you have an employee who has developed a physical disability, or maybe they've become pregnant, or maybe they have something else going on, and they're a receptionist. They work in reception in your office, and they say, "You know what? The two times that I'm allowed to go to the bathroom, they just don't work for me anymore. Medically, I need to be able to go, but I know I can't leave the reception desk unattended." And the employer says, "Well, that's fine, but when you need to go, you need to email the 50 people on this floor and see who will cover you." That's not really an accommodation with dignity. So we want to talk about finding solutions, not that just work, but that work well and that are respectful of the employee's needs. They need to be personalized. And this is something that sometimes employers can struggle with because each employee's needs are unique, even if they have the same diagnosis. Blanket accommodations don't usually work and they're not acceptable. You have to look at the individual need. So an example of this would be sometimes larger employers kind of develop an approach to accommodation, which is great, but they can sometimes develop, okay, when an employee discloses that they need accommodations because they have ADHD, here's what we do. And that's not individualized. Each individual, even with the same condition, may have different needs. And so we want to make sure that all accommodations are personalized and that we have a good understanding of what the individual actually requires and how to best accommodate that. And then inclusion. We want to make sure that there's a process in place for accommodations, that accommodation requests are welcome in the sense of people feel comfortable having that conversation. You want to, where possible, allow flexible schedules for employees with perhaps family status obligations. And you want to consider modifying infrastructures to make them accessible. So if you're thinking about doing renovations to a space, give consideration to not just who's in your office right now, but who might be in your office down the road, and make sure that the spaces work well for as many people as possible. I think it's always good to, as an employer, to let folks know that accommodation requests, we have to expect them. We have to understand that people, especially if they're at the same employer for a long time, their life is going to change and their needs are going to change. So an example of this would be, It's the start of school this week. Schools all have different schedules this week. Some schools are starting, a half day, or they're starting a different day, or you need to go in to meet the teacher. Something that employers can do is have that conversation and say, I know that, back to school is coming soon and you might be seeing some changes to your schedule. Please talk to your manager about what your accommodation needs are, if you need any flexibility, so that they can have that discussion about what the options are. It's good to set the environment to make it so that people feel comfortable having these conversations. So what does this look like in practice, and what does this look like in case law? We're going to look at a few case law examples. I do just want to advise that the first example, so the next slide, does deal with pregnancy loss. So I want to give the warning in the event that anyone would like to maybe momentarily pause or take off their headset. We'll be on the slide for about 30 seconds. So this first example, we have this employee working for an employer. In this case, it's Subway. This was in 2001. And she needed to miss some work because she was having pregnancy-related complications. She tells her employer about the condition, so the employer is aware that this is what's going on. And subsequently, she experiences a miscarriage and a hospitalization. The employer refused the documentation for the leave and terminated her employment for absenteeism, despite their knowledge that there was a situation occurring. So this went to a tribunal who determined that miscarriage is a part of pregnancy conditions, which is protected under the Act, and that the employer had an obligation to accommodate the employee to the point of undue hardship, and that this employee really should have been given the opportunity to provide medical documentation. Sometimes we try to provide it in advance, but if there's an emergency, you may need, to recover first before you can provide that medical documentation. As a result, the individual was awarded $3,500 as general damages, which is damages for injury, self-respect, feelings. And I'd like you to just pay attention, because this case is about almost 25-ish years old. And you'll see as we move through time here, a little bit of change in general damages overall. So the next case involves an individual who was refused a job. So was initially kind of successful in the process, but was refused a job because he was missing a finger. And the employer determined, without consultation really, that he would not be able to perform the job as a result of not having that finger. So the employer believed that really, in order to do this job, an employee needs to have all 5 fingers. That was their belief. And so the tribunal did what's called the Mayoran test, which determines whether or not the discrimination was justified. So there's certain cases in which discrimination can occur, but it can be justified because there's a rational reason for it. It's almost required. So an example might be a pilot requiring vision to fly a commercial flight. There is a rational reason why that might be in place. So they went through this test and they determined that, okay, the idea that somebody would need their full hand was kind of connected to the position. The standard was adopted in good faith in the sense of the employer really believed that that was the case. But what the employer didn't do was actually ask the employee if they were capable of pumping gas. They did not go through any process to determine, can this individual do the job regardless? So this individual received $2,000 for general damages and $21,000 in lost wages. The next example, a little bit newer, has to do with an individual who's working at an employer and has been for a little bit, and a shift change occurs. This employee has children, and this employee requests that instead of having the shift change, they'd really like to be able to be home in the afternoon to be with their child who has a medical condition. The employer does not accommodate that request, despite her communication to them about her concerns. The employer is unresponsive. The employee tries to apply for a different position. She ends up being terminated. So what the tribunal found was that the employer had failed to accommodate the needs, and so this would be under family status. They awarded the individual $30,000 as general damages. And finally, the last example here is an individual, a woman working at a gas station who had a mental disability. At a certain point during her employment, she's struggling with her mental disabilities, and she needs some time off work, which is supported by her physician. When she comes back to work, her manager refuses to schedule her for shifts, which is effectively a termination because individuals have an expectation that they're going to be able to work. And so this individual received over $4,000 for lost wages and $15,000 as general damages. So you see that, from 20 years ago, we saw kind of lower general damages. We are seeing a trend of increasing general damages for incidents of discrimination. So how are physical and mental disabilities defined under the Act? I think it's important to talk about. Physical disabilities and mental disabilities are defined in the Act, but they can encompass more. So physical disabilities could be diabetes, epilepsy, visual impairments, chronic conditions. It could be something like cancer or multiple sclerosis. A mental disability would be an intellectual or developmental disability, a learning disability, a mental health condition, so that, depression, PTSD. It doesn't have to be a permanent condition, but it can include certain kind of transitory ailments, so maybe pneumonia, but it's less likely to include something like a cold or a flu, something that's experienced by more percentage of the population at a higher rate. And the ground of disability also protects individuals who use a service or emotional support animal. And in New Brunswick, the Act treats those two as being the same. So even though there are differences, a service animal might perform a service of alerting, someone who's about to have a seizure or indicating that there's an allergen present, whereas an emotional support animal might provide, support or comfort to someone with maybe anxiety. They are seen as the same in New Brunswick, and the duty to accommodate is also the same. This is really important, and talking about accommodating disabilities is really important because in 2022, a survey found that 35% of New Brunswickers live with a disability, being the second highest rate of disability in any province. Many people, as you'll see here, 55% reported facing barriers in terms of accessing facilities. Those could be related to communication, behavior, misconceptions, or assumptions. I think the key message here is that over 1 in 3 New Brunswickers are living with a disability. We shouldn't be surprised by requests for accommodation. We should be prepared for them. We should know that they're coming. Not everyone with a disability requires an accommodation, but a percentage will. We shouldn't be surprised by it. This is also reflected in the Commission's own data. So traditionally, mental disability and physical disability are the highest percentage of complaints that we receive. And those can be in the areas of both employment and services generally. Employment is usually around accommodations, and services can be around accommodations or failure to accommodate as well. It's important to note that even though we do see this high percentage of mental disability and physical disability complaints, one of the things that we're interested in is whether people feel more supported, whether they feel more comfortable filing on those grounds than other grounds, whether people are more aware of their rights when it comes to disability and accommodation. But regardless, we do see this high percentage of complaints in those grounds. So what are the responsibilities of an employer when an accommodation request is made? Information gathering. We need to know what the request is, and we need to understand how that request should be implemented. So we're going to have some information gathering, which could be information, and usually when it's an accommodation request would be information from a doctor, a specialist, an OT, indicating that this individual needs an accommodation and this is what the accommodation looks like. The employer has the responsibility to provide suitable and reasonable accommodation, which could be modifying a position, modifying a space, allowing time away if there's a need for a leave. The employer, to the best of their abilities, needs to maintain confidentiality. This can be difficult, obviously, in small staff groups or small offices. If someone's away on a leave, it's probably going to be noticed. But to the extent possible, it needs to be confidentiality needs to be maintained. We don't want to perceive disabilities or limitations where they don't exist. So if an employee comes to you one day and says, I'm struggling a bit. I've struggled with my mental health in the past. I'm struggling now, but I'm doing okay at work. Things are going okay. It's just, it's been a lot. I'm just tired. It's important that the employer doesn't then maybe say, maybe the next week they're asking folks to travel for a work event. They say, oh, well, we won't ask Jan this time because we know she's got a lot on her plate. We don't want to make assumptions. It's important to have the conversation about whether an accommodation is needed or not. Accept the accommodation request in good faith unless there's really a reason not to. So if an individual makes a request or presents with a medical note, we should be proceeding in good faith on that. We should be attempting to find a solution. And always document the accommodation requests and attempts. So any correspondence should be documented to make sure that everyone's on the same page and there's no miscommunication. If you've had a meeting, it's great to have the follow-up email to say, here's what we talked about and here's what we both agreed to. Let me know if you have any concerns. And always document anytime an accommodation request is not approved or it's rejected, make sure that there's a documented reason why, and keep all the kind of evidence to support that. Also, think about all the means of accommodating someone. So we might have somebody who does a really physical job and they now have a back injury, and their physician says, well, for the next 2 months, we don't want you doing any lifting. You need to look at jobs outside of that role. Are there other things that individual can do for that limited amount of time? Can we rebundle tasks? Can we maybe shuffle things around? Maybe we move a few tasks to this employee and the employee requiring the accommodation takes a few off that list. We need to provide reasonable accommodations in a reasonable time frame. Accommodate disabilities, even if it's not a work-related injury. This is a common misconception that the employer only has a duty to accommodate disabilities resulting from an injury at work. It's not the case. All disabilities, whether the individual was skiing with their kids, whether they were maybe doing something a little bit silly and became injured, whether they were actually in fact injured at work, whether they slipped on ice, all of those things, the duty is still the same. The accommodation needs to meet the needs of the employee as determined by a treating professional. So you don't make the determination as the employer as what's acceptable. It needs to be on the recommendation from the physician. And certainly the employer can ask questions if the information's a bit unclear. And it can also include, keeping the position open for that employee to the point of undue hardship until they're able to return. So like I said, employers do have the right to request additional information supporting the need. So maybe the medical note's a little bit vague, or it says, this person can do no lifting. And the employer thinks, well, does that mean 5 pounds? Does that mean 50 pounds? What does that mean? The employer can ask for additional information. They can ask for the physical or mental limitations or restrictions. They can ask for any ideas on accommodation. They can ask for the prognosis, for example. So how long do we think this is going to be in effect? They don't have the right to a diagnosis. So sometimes employees choose to disclose that, and that's fine, but it's not a right of the employer to know the diagnosis. And if there's an accommodation around religion, the employer does have the right to ask for more information about what that accommodation needs to be, usually from a religious leader. Generally speaking, though, when we're handling requests in good faith, unless there's really a significant concern, we would encourage folks to just have that conversation with the employee. So the employer can be found liable if they fail to accommodate. If they fail to provide a reasonable accommodation, if they're not providing a harassment-free workplace for an employee with a protected ground, or if they're not doing it in a timely manner. We see this sometimes, if an individual requires a change to their workspace and it takes 2 years, is that really a reasonable accommodation? Probably not. We don't want to offer accommodation that limits independence or do anything that results in a demotion for the employee just based on a protected ground. So employers aren't obligated to make accommodation efforts without documentation. So if the employee approaches and says, I need an accommodation for this, the employer has the right to say, okay, I need medical information to support that. Can you get that for me? If the employee never does and you follow up and they say, no, I'm not going to do that, the duty to accommodate is not triggered. The employer has the right to know what the accommodation needs to be to see if they're able to do it. They're not obligated to create a position that isn't viable or useful to the company. And they have to accommodate to undue hardship, but not beyond. And there has to be proof of that. So employers aren't allowed to know the diagnosis. They're not allowed to request it. They might know it, but they're not allowed to request it. They're not allowed to know specific medications the individual will be on, but they are allowed to know side effects. So they could ask the physician, are there any side effects from any medications this individual is on that I should be aware of? And this can also help the employee, for example, if they're on a medication that might make them really drowsy and the employer comes in one day and sees them sleeping at their desk, it might make that conversation a lot easier if there's that base level understanding of where that might be coming from. They're not allowed to access the employee's medical records. So rights and responsibilities of the employee, so the other side of the coin here, the employee is entitled to reasonable and timely accommodation, an accommodation that meets their needs. They're entitled to privacy. They do need to provide adequate notice of their need for accommodation and to accept reasonable offers of accommodation, even if they aren't the perfect solution. Um, we have to understand that if a request for accommodation is made, some of them, it might be possible to put them in effect right away. Some of them might take longer. If we're talking about ordering a new chair, it's probably not going to happen in a week. It might take some time. And so the employee has to understand that it's going to take a little time in that situation. And the employer also has to work hard to do it as quickly as possible. Employees have to work with the employer. So the accommodation process, it's a two-way street, it's a collaborative effort. So they do need to provide the additional medical information when requested, provide documentation about needs for accommodation, and take reasonable efforts to make sure that the accommodation is successful. If an employee refuses reasonable accommodation, a complaint of discrimination could be dismissed. Or if an employee fails to facilitate the implementation, if they just refuse to do certain steps that would be required for no real reason, that could also result in a complaint being dismissed. So examples of what accommodation can look like in the workplace, there are so many things that it can look like, and it depends obviously on the individual's needs. But it could be managing a schedule in a way that meets the employee's family caregiving needs. So the example we used earlier of the start time of 8:30, maybe, or the drop off of 8:30 for childcare, maybe that employee starts at 8:45 and works a longer, a longer day. Allowing an employee with a disability to take time for medical appointments, allowing a transgender employee to use the bathroom that aligns with their gender identity, making changes to an employee's workstation if they have a physical disability, reducing an employee's workload to help them manage a mental disability. This can look like reducing the workload or reducing the workload in certain areas. So maybe you have someone who is doing a lot of phone calls, and for whatever reason, they need to reduce that. And so you move them over to responding to emails, or allowing an employee to wear a hijab, even though, all employees are required to essentially wear the same corporate clothing. Accommodations are always up to the point of undue hardships. There are limits, and there are real reasons why an employer or a service provider or a housing provider might just not be able to do the accommodation. Undue hardship is really hard to define because it has to be assessed based on the information that's there. It has to be assessed based on evidence, and it's always on a case-by-case basis. Can't be based, though, on minor inconveniences or used as just an excuse to refuse a reasonable request. Factors that are kind of more commonly seen could be the cost of the accommodation, health and safety considerations, disruptions to the work operations or business, substantial interferences with the rights of other employees, very long absences, or inability to perform essential job duties. All of these have the caveat of in some workplaces, it's not going to be undue hardship, and in some places it is. But a health and safety accommodation, for example, you might look at somebody who maybe they've been prescribed medical cannabis and they need to use that for a health condition. However, they're a forklift driver. We would still have the expectation that the employer looks at other opportunities for them within their organization, but that might be undue hardship. Cost analysis has to be realistic. We're not looking at inflated numbers. If somebody's saying that an accommodation costs too much, we're going to ask for the quotes. We're going to ask for what they did to make that determination. We're going to ask to make sure that they looked at all the other options. What other positions did you consider? Were those feasible or not? Inconveniences and preferences are not undue hardship. We need actual documentation. So if you're dealing with competing rights, for example, where perhaps other individuals have an accommodation in place and this accommodation would be directly opposed to that, we would be looking for evidence to support that. The commission, if you call us, we can't give you legal advice. We can explain the information we'd look for if we're looking at undue hardship, but we can't tell you definitively whether it is or isn't. Since we can't make a finding of discrimination, it's really only a board of inquiry that can determine whether or not it's sufficient or not. Our commission members can also make recommendations on bona fide requirements and whether, whether they feel undue hardship has been met. But employers really should consult with a lawyer on that if they're looking at claiming undue hardship. So a few examples, maybe a really small business, they just can't make expensive changes to employees' workstation. a business with few staff members can't provide extended leave for an individual because of the strain on other workers. This would have to be demonstrated strain. And a construction company that operates heavy machinery, maybe they can't accommodate an employee with an alcohol addiction because of safety concerns. In every case, an employer is still going to be required to show that they really gave consideration to any other options, that they looked at other positions, other roles, even position reduction, things like that. When it comes to files that might involve WorkSafe, we want to make sure that employers, employees, and WorkSafe are all collaborating. WorkSafe has a process in place to deal with accommodations and return to work, but employers really have to be careful not to solely rely on WorkSafe information. They need to have conversations with the employee about accommodation as well. So they should take into account information from the employee, information from the healthcare providers, and information from other sources before making a determination. Even if an employer determines that the accommodation, an accommodation based on information provided WorkSafe, they could still be liable if they don't properly put in place that accommodation or if the employee raises concerns with it. WorkSafe doesn't have the final say when it comes to accommodations in terms of their obligation under the Act. And again, key message is that employers really do have the obligation to accommodate all disabilities, not just those resulting from workplace injuries. And it's really the same as whether the person had a disability when you hired them or developed a disability over time. And employers can always contact the Commission if they have questions about the duty to accommodate. We do have a number of publications available, and we've highlighted here Accommodating a Disability at Work, which is a 2017 guideline. It's a lengthy document, so we also have developed plain language versions of some of these that are 2-pagers. We encourage folks to take a look at them. If you have questions, take a read through, see if it helps answer some of those. Both employees and employers can benefit from looking at this information. We also have a number of other documents, including, accommodating people with service animals, accommodating individuals in education, guidelines on housing and other forms of discrimination. And for a number of those, we do have the 2-page flyers available. We also have a basic kind of document. It's a 2-pager on human rights in New Brunswick. And we really encourage employers to share this with their staff. We want to make sure that individuals know what their rights are, but also what their responsibilities are. These flyers here are available in English and French, but also Arabic, Tagalog, Mandarin, Swahili, Ukrainian, and Spanish. We have an online presence. If you want to know more about the Commission, you can always check out our website, our Facebook page. We do release an annual report every year. And every year, despite the fact that we deal a lot with compliance and with kind of maybe stories of where things haven't gone right in terms of human rights, we do celebrate human rights heroes in the province as well. So every year we do the Human Rights Awards, where we award 2 awards, one to a youth leader and one to an organization or an individual advancing human rights in the province. This year's awards are coming up very, very soon. They're next week. Nominations always open around May, though. So if ever you're thinking that you know someone who's really doing a lot in the realm of human rights, you can certainly nominate them. We have, like I said, YouTube, Facebook, and Twitter, and we do other types of events. You can always contact us if you have any questions. We're always happy to give as much information as we can. We can't always give legal advice because that's outside of our mandate, but we can certainly give information about the parameters of our Act. And I'm happy now, I think, to hand it back to Amber and the team if there's any questions.
Wonderful. Thank you so much, Megan. That was packed with information, and we do have quite a few audience questions, actually. And some of them are quite detailed, so I'll jump right in. The first question that came in says, it's more of a comment, but I think there might be a question in here. GNB has a policy for working from home, and it specifically mentions that it can't be allowed for childcare or caregiver purposes. But a lot of times children are sick and working from home, and it gives more scope of not missing work, given that it's only a matter of the parent needing to be home, not necessarily attending to the child all the time. It's only a matter of someone being present. So I think that's more of a comment about work from home policies being, accommodations, but maybe given on conditions, specifically with the condition that it not be used for childcare.
So I can certainly provide a little bit of information about that. So family status which is I think what we're talking about here, is a really interesting ground because family status has a little more maybe burden on the individual seeking the accommodation to seek out alternatives. So questions that might be asked of the employee are, okay, so if your child is ill, are there any other alternatives? So is there alternative care, which might be an option, but for many people it's not. You have a sick kid, a parent needs to be home with them. But the next thing is, are there other options? And unfortunately, in this context, the option might be maybe it's using a family day, maybe it's using a unpaid day. The employer has a duty to accommodate, but they don't necessarily have a duty to accommodate in the way you would prefer, which might be that you take your laptop home and you're able to work from there. So if someone was to file a complaint about that, we would ask some questions about what alternatives were considered. We would also ask as to whether there was any negative outcome for the employee. So were they disciplined because they needed to stay home with their child when they really had no other option? Or did they not have access to their preferred accommodation, which might have been working from home and the employer said, no, you need to take a family day. So those are kind of different things, and that's how we would look at that question.
Gotcha, thank you. Another question, what kind of proof must a disabled employee provide an employer in order to request accommodations? And what protections for medical privacy are available to employees? So for example, if an employer requests medical documentation or a diagnosis, and then they also add, also given the massive shortage of primary physicians and medical access in the province, what's being done to ensure that New Brunswickers have access to medical services so they can provide the required documentation?
So in terms of the documentation that's required, we would encourage all employers, once they become aware of the need for accommodation, to consider the accommodation process at least partially triggered. So if an employee says, I have this situation that's occurring, I need an accommodation, the employer can ask for the medical documentation to support, and they should work with the employee to kind of provide some flexibility around maybe the timeline to maybe accommodate them in good faith in the meantime. It is a huge challenge for individuals that don't have a primary care physician. The employer needs to consider information coming from other sources. So that could be an OT, that could be maybe a counselor, maybe some, different types of medical practitioners that may be more easy to access. And it depends on the scope of the accommodation. If it's a minor accommodation in the sense of there's really not a significant impact, the employer might just want to accommodate in good faith in the meantime, depending on the length of it. But the employer does have the right to ask what the accommodation needs to look like. And that's partially to make sure that the employer's not accommodating in a way that's further harmful. So they do have the right to ask for it. Flexibility, given the current shortage around timelines and things like that, is usually something that we suggest. And the Commission doesn't have any jurisdiction over healthcare services in terms of the availability of physicians, so I wouldn't be able to speak to kind of the what's being done portion.
Wonderful, thank you. Another question, who can we contact about questions if something is worth pursuing regarding an incident that happened in the past or maybe at risk of happening again?
So you can always contact the Commission. So we won't be able to answer, is it worth pursuing? What we can tell you a little bit is what would happen if you did pursue it. So what we would get you to do is explain the situation to us, and we could tell you whether or not we think we would have jurisdiction over that. So if you're able to identify a protected ground and you're able to say, I think this thing happened because I have this protected ground, or I was negatively impacted in some way because of this, then we would probably have jurisdiction as long as it's in one of those areas like employment or services. Then what we could do is explain to you what would happen if you filed a complaint, and if your complaint was successful, maybe what kind of the reasonable range for general damages or potential outcomes could be. Outcomes can be financial, and they often are, but they aren't always. Sometimes it's reinstatement, it's a letter of recommendation, it's a change to a work practice, it's an accommodation, it's those things as well. So we'd be able to explain whether we think we'd have jurisdiction, and whether or not you want to pursue is really up to you. We can tell you what you might expect from the process.
Wonderful. So maybe before the end of the session, we'll drop some information on how to contact the Human Rights Commission right in the chat so that people can access your website.
Perfect. Yeah.
Another person says, I had an employer request that I sign a form for complete access to question my physician. You stated a moment ago that the employer does not have the right for medical prognosis, et cetera, yet Human Rights didn't address the issue. So they're just wondering maybe what they can do or why they have conflicting information. Do you have any idea?
So obviously each situation is individual. They do have the right to the prognosis, though, just not the diagnosis. Um, Sometimes the diagnosis can be evident, if there's been a workplace injury or if there's been, sometimes they do know the diagnosis inevitably or it's been disclosed. Um, Depending on the way they're requesting the information, that can vary, and what questions specifically they're asking. We often see employers provide fit for work forms, which might have a number of questions about limitations and things like that. Those are generally acceptable depending on the questions that they're asking. So it just depends on the individual situation. If the person were to file a complaint, the commission would look at what information was requested and what the intention of that was. It should also be noted, and I don't think I've mentioned it yet, you have 1 year to file a complaint with the commission from the date of the alleged discrimination. So the clock starts ticking from the day it happens to you. You have 1 year to get your complaint in, and that's just per the Act in New Brunswick.
Yeah, those limitation periods can be tricky too, huh? We have a person who asked if the presentation can be shared, and I'll just make sure that everybody knows that we are recording our presentations today, and they'll all be available on Please NB's website where you would have registered for Respectful Workplace Week. So you can access the recording of this presentation shortly after the week concludes and go back and watch it anytime. Last question that I see here, and again, for anybody here in attendance, feel free to send in your questions if you have anything else that you'd like to ask. It says, what happens when the employer asks for private medical information when no accommodation has been requested? This person says they received a very detailed and invasive form that their doctor suggested they contact the NBHRC if they wouldn't accept her answers on the form because it was private medical information. So any thoughts on this? Is this within the scope of the NBHRC to comment?
It could be. So there's reasons that an employer might ask for medical information. That could be if you're in a safety sensitive position and they have the requirement to establish certain parameters to that role. So, for example, if you're carrying a firearm, they may be entitled to ask for certain information. The other one would be observables. So sometimes an employer observes something happening in the workplace. Maybe they know the employee really well. It strikes them as being really out of character for them, but it is concerning. That could trigger the employer to ask for medical information. Um, Generally it's best if the employee doesn't see that as being malicious, but more as trying to understand whether an accommodation is needed that the employee either has not wanted to disclose or maybe isn't even aware of themselves. It does happen sometimes. And so the employer might ask for the medical information then.
Great, that makes sense. Another question just came in. Somebody's wondering if the employer is entitled to know which medications an employee is taking or only their possible side effects.
Generally, I think the case law supports that they can know side effects and not the specific medications. Although and I don't have our general counsel here, I do suspect there may be certain limitations to that, depending on the position and the specifics. If anyone had a question about that, you could certainly contact us, and we would have our legal crew take a look at it and see whether there was any information or case law around it. But generally, what we say to employers is not the medication names, but the side effects.
Great. And if you take a look in the chat, you'll notice that we just dropped links to the New Brunswick Human Rights Commission's website. So if you're looking to get in touch with any other questions or to follow up on any of the stuff that you brought up here today, feel free. Any other questions for Megan, please feel free to drop it in the Q&A. Thank you so much for being here with us, Megan. Oh, one just came in. When one does not agree with a human rights decision, what can they do about that? Is there a mechanism to pursue that or to hold it accountable if they disagree?
Yeah, so we're a legal process, so there are certain avenues available. So if it's a dismissal at the director level, so a letter saying we're closing your complaint and this is why, we include the information about how you can appeal that to our commission members. So it's a different decision-making body who would look at it and determine whether or not new facts that you provide or the information supports maybe reopening the file. So that's one option. If it's a final decision, meaning it's a decision made by commission members, the information that we would have around that would be that you would have to judicially review that through the court system because those decisions are final. So just like any other decisions, judicial review is an option for those. And then finally, if it is a labor and employment board decision, for example, relating to a matter, we would direct you to them to discuss that. I believe judicial review is still an option there.
Sorry, I muted myself instead of unmuting myself. If a person were looking to pursue those processes, would they be able to get that information through the human rights staff?
So we can give you basically the standard information, which would essentially be that you need to contact the court
Right.
because the court will have their own processes. We just always advise individuals that there are time limits to everything. If you do have a concern about potentially bringing forward a human rights complaint, the sooner you call us, the sooner we can explain to you what the limitation periods are on that. It's 1 year from the date of the alleged incident, but there are also limitation periods around appeals, 30 days for us, and around filing judicial reviews. So you would want to get that ball rolling very quickly.
Great. I do see a question, one last question before we wrap up for our 5-minute break. And this is a process question about appearing. Is it possible to appear personally before a tribunal if they're doing that kind of judicial review of a decision? Do you know if
So
that's
how the process works is when it's internal to the commission, there are no, we don't have parties come in. So we might interview you as part of the process, and that could be in person, but you don't kind of make your case to commission members. They're presented with the facts, the information, and they make the decision. When it comes to if the commission members make the determination to refer a matter to the Labor and Employment Board to sit as a board of inquiry, that's public. And yes, if you're a party to the complaint, you will likely be called. You will testify. It works very much like court. So that part, yes. Internal commission processes, no.
wonderful? Thank you so much, Megan. This was a really informative discussion. It was so valuable, so much insight and information for people about a process that I don't think a lot of people are generally really well informed on. So thank you so much. We are going to take a quick 5-minute break. And please note that there was a feedback survey also shared in the chat. So if you have any feedback about this session, this is a shorter survey just for the session specific feedback that you might have rather than the forum as a whole. So feel free to click on that if you have any comments or feedback on how this went or how we've planned the sessions so far. We'll resume at 2 p.m. for our next session called Can't Buy My Silence, Non-Disclosure Agreements in Workplace Harassment and Abuse Processes. So we'll take a quick 5-minute break and then come back for that. Thank you again so much, Megan.
Thank you, everyone.